Morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to SmartLoc TV. If you haven't already, please go ahead and hit that like button, that subscription button, then turn that notification bell on. And I'll give y'all a second to do that. All right, so I'm just going to jump right into this. So in this video, I'm just going to be picking up where I left off in the previous video in regards to the arguments that so-called sovereign citizens make. But at first, I want to start off by saying again that I don't know what a sovereign citizen is, other than the fact that it is a misnomer. And I know that for a fact it is a misnomer because the people are sovereign and we don't have a democracy, we have a republic. And the people can, whenever they want, change their constitution at will. So, but in this particular video, I finally got evidence from somebody in regards to the name argument. He actually has this transcribed in a document, and he sent me the document. But when I got the document, I did go and censor his private personal information. But you're going to see and you're going to read where they're going to say it on the record that they don't have jurisdiction. I'm not going to tell you over what until we read the document. But anyway, before I do that, I'm going to play this little small clip, probably about a minute or two from Yusuf, and let him elaborate on it a little, and then I'll be providing y'all commentary on some of this stuff. Let's go.
Of the action. Okay, so is it correct? There's a Sixth Amendment for the Constitution of the United States of America. I always say this. I always say it because it's like scratching your nails against a chalkboard when you say Constitution for the United States of America. And like throwing holy water on a goddamn vampire. Now, sir, according to the Constitution for the United States of America, it is my understanding that I have a constitutionally protected right to know the nature and cause of this action. Is that not correct, sir? For the record. Well, yeah, that's correct. Okay, thank you. Let the record reflect that this court has established for the record that I do have a constitutionally protected right to know the nature and cause of this action. Now, sir, I have another question. Is this action criminal or civil, sir? Well, this is a criminal action. Thank you. Let the record show that the action being brought against the defendant, you're going to say against the defendant because you're not the defendant. The defendant is the all caps name on the paper. So the action being brought against the defendant is a criminal action. Okay, sir, I have another question. The Constitution for the United States of...
All right, I'm going to stop right there. Back to where he was saying that you're going to say that the action is being brought against the defendant and not you because you're not the defendant. The defendant is the all caps name. So, let's go here. This is the document that I was talking about. All right. I want to point out something, to y'all before I go over this document. You see this right here? It says Milwaukee County. That is a corporation, just to let y'all know. That is also an administrative agency, just to let y'all know. See this right here, Circuit Court? That is a corporation, okay? It's a corporation. It is also an administrative agency. They're acting in an administrative capacity because they are in there enforcing statutes. That's what they're doing. So when they're in here enforcing statutes, they are so-called courts of limited jurisdiction. They are not courts of general jurisdiction. In other words, this is an inferior, whenever you go into a so-called circuit court and they're in there enforcing statutes, okay, that is an administrative so-called court, aka inferior court, aka legislative court. That's where you at. Let's go on down. See this guy, the guy was pro se. This was this year. Not gonna tell you when or nothing like that. He got it transcribed. Okay, so I'm gonna go ahead and read y'all the most important parts that I think is important. I'm not gonna read the whole thing because it would just defeat the purpose of this video. But I will tell you that the case against him was dismissed without prejudice, so they can bring the action back if they want. Although I highly doubt that they will, based on the facts and circumstances of the case. But you just never know dealing with these people. But anyway, the clerk calling the case the state of Wisconsin versus. This case is assigned to branch 19 So we're going to go on down. I'll just let y'all read that. My main focus is getting to the jurisdiction. I want y'all to pay attention, because even though this says court, this is in Wisconsin, but even though this says court, there's a county commissioner in there sitting on a so-called bench, sitting somewhere. I don't know. I wasn't there. But they're sitting and they're acting like a so-called judge, okay? That is not a judge in the sense that it has authentic judicial authority granted to it by the sovereign people of Wisconsin. Okay, this is an administrative agency that is exercising plenary power. They call it quasi-judicial authority. I don't call it that. I call it plenary power. That's what I call it, and that I'm convinced that I'm right until somebody shows me that I'm wrong. But anyway, there's a county commissioner in there doing this. It's going to say the court. Anyway, see this, I will issue a warrant, any bail, posted, forfeiture, all this stuff. You know what I'm saying? Just acting or representing the so-called court. So let's see. Right now, the black, what you see right here is the name. Give me a second, y'all. Let me pause the video. Somebody's calling me. I'll be right back. All right, y'all. I'm back. Sorry about that. But back to what I was saying. The censored part is the name. You know, and I'm trying to maintain their privacy, so to speak. Excuse me. Okay, so let's go down here. Right now, they're just talking about issuing a warrant and all that stuff. If the defendant does not show, or the alleged defendant does not show. Okay, so they did a little quick recess, 2-minute recess or something like that. And then they're recalling the case. Recalling the case, State of Wisconsin versus blah, blah, blah. This case is assigned to Branch 19. Mr. Herman, Greg Herman for the state, the defendant in person, so-called court, all right. The defendant on behalf of blank trust. Court, all right. Just so you understand, Mr. Blah, I'm blank or whatever, I'm not going to say his name. I don't want to. If you have truly, in fact, changed your name, the judge has the power to maybe tell the state to change the name that you've been charged under. Right now, I have to refer to you as the name. That's what he tried to say. It says named right here, but he says it should have said name. As the name that's charged in this complaint, or I will be responsible for the defendant, even with a court order. Wait till I'm finished. The defendant, okay. Wait till I finish. Or I will be responsible for losing jurisdiction over you, because as far as the state of Wisconsin is concerned with this case, you're charged under another name. This is that name, that legal name, that belongs to them. That social security number and that legal name, in my opinion, are synonymous. It's like they're inseparable. They're the same damn thing. So whether the social security number is used or the name, it doesn't matter to me, in my opinion. They have jurisdiction or territorial jurisdiction over that name. It's always been about the name. I've actually used this argument before. It's not on record. I was in municipal court. I was new to this stuff, just trying some stuff out. I've never heard of this stuff before, but I was doing research on the internet. So I decided, I got a traffic ticket or something like that, and I decided to try it out. And, I go up, the administrator, because she's not a judge, she calls my name or whatever. She was wearing a black robe, acting like a judge, but this was in municipal court, in a city court. A city, just to let you know, is an administrative agency, okay? A county is an administrative agency. The Department of Justice is an administrative agency. DHR, CPS, the FBI, the ATF, the police department, the sheriff department. Those are all administrative agencies because they are following statutory procedures and they are enforcing statutes. However, generally speaking, most of them are administrative agencies of the legislative department. However, the three branches of so-called government, the legislative, judiciary, and executive, they are administrative agencies of the people. Those agencies belong to the people, and the law of the sovereign that they are administering is the Constitution. That's what they're doing. Anyway, but he says, I would be responsible for losing jurisdiction over you because as far as the state of Wisconsin is concerned with this case, you're being charged under another name, blah, blah, blah. Now, when you eventually go in front of the judge, if you show the judge that you in fact change your name, she may or he may be able to change, blah, blah, blah. I'm not going to read the rest of that because it's pretty short, straight to the point. I'm not going to read all of that, but I just want y'all to see that. So now I'm going to go to a document that I drafted to show y'all what is going on here. There are two forms of so-called laws in place here. So I drafted this to give y'all an idea of what's going on here. So we're going to start right here. The English word person derives from the Latin persona and originally meant mask. So your legal name, the one that was created by the government and the one that was issued a social security number, is a mask. It's a mask. That person, that legal person, that juristic person, that juridical person is a mask. I'm gonna stop right there, and then I'm gonna show y'all something else. Now, right now, this is the Black's Law Dictionary, 8th edition, which is my favorite. And you'll see the word person here, but I want y'all to see all of these definitions, these legal definitions for the word person. And you have to use your wits, based on all of your research to ascertain or to find the correct sense in which this word is used. Let's go down. Right here. Right here. Person. Now, I'm going to use this one right here because, in my opinion, based on all of my research, this is the sense in which this word is used. An entity, such as a corporation, that is recognized by law means statutes, as having the rights and duties of a human being. In this sense, the term includes partnerships and associations, whether incorporated or unincorporated. So far as a legal theory is concerned, a person is any being whom the law regards as capable of rights and duties. So essentially, it doesn't matter if it's a real living flesh and blood man or woman or not. Now let's go down here. I want to show y'all something what the well, that's going to be an artificial person, so that'll be right here. So this is what you call a juristic person. That legal name is a juristic person, aka legal person, aka juridical person. And it says see artificial person. All of these right here say see artificial person. So we're going to go up. See right here, artificial person. An entity such as a corporation, created by law, which is statutes, and given certain legal rights and duties of a human being. A being, real or imaginary, who, for the purposes of legal reasoning, is treated more or less as a human being. An entity is a person for purposes of the due process and equal protection clause, but it is not a citizen for purposes of privileges and immunities. You see, this is why you need to read. These people are sorcerers. They are wordsmiths. I have read cases where there are pages and pages long where they are arguing over the definition of one damn word. And they are trying to substantiate this in this case. I've read cases like that. So you are crazy if you think you're going into court and these words do not matter. They do not make mistakes when they use these words, generally speaking. They pick these words very carefully. These so-called attorneys. Now let's get back to this document right here. The English word person derives from the Latin persona, which originally meant mask. And there's the case right there that supports that contention. Okay, so these are some examples that I'm providing to you. So a little girl dresses up in a princess costume for Halloween. The princess costume is her person, aka mask. I have to do this so this can make sense for y'all. A little boy dresses up in a vampire costume for Halloween. The vampire costume is his person, aka mask. Okay. John Henry Doe's person, aka mask, is John Henry Doe. They are never going to tell y'all this. I can't even believe that the guy went in court and they actually admitted this on the record. I cannot believe that they did, and he actually got it transcribed. I can't believe that they did that. The name, this all caps name, this name belongs to them. It exists in another jurisdiction. Jurisdiction is not a geographical area. If it is, I don't think it's used in that sense as being a geographical area. All right, so back to it. John Henry Doe is governed by private law, common law, and equity. So what do I mean by that? So let's say John Henry Doe, is assaulted by James Smith. Okay, and John Henry Doe wants to sue James Smith. What does he do? Well, first, he would draft what is called an action at law. Okay, and he would allege facts to substantiate why he is suing James Smith for assault and battery. Okay, and then he would probably pay some sort of fee or whatever in gold and silver. I don't really know. In gold and silver, and he would file that action at law, either in a court of law or what they call today a court of general jurisdiction, aka a superior court. That's what he would do. Or let's say John Henry Doe, gets into a contract dispute with somebody by the name, we're gonna say James Smith, another private citizen, just like the previous James Smith. Okay, a contract dispute. So he wants to take this to court because James Smith is just exhibiting numerous traits that are contrary to equity. So James Smith would draft what is called a bill in equity, aka a suit, and he would file that suit in a court of chancery, or what is called today a court of general jurisdiction, aka a superior court. He would never use statutes because he does not need to use statutes, whether he's filing his common law action or his bill in equity, aka the suit, is independent of the statutes. Common law and equity are independent of statutes. Okay. All right, now John Henry Doe is synonymous with 1, 2, 3, 4, 5, 6, 7, 8, 9. So this is, in other words, this is just a social security number, just to let y'all know. But I couldn't, I had to make up something. All right. John Henry Doe is governed by public policy, statutes. All right, statutes. I want y'all to understand something right here. John Henry Doe is not governed by the Constitution. So we're gonna say that this is in Georgia. Okay, so John Henry Doe, this John Henry Doe right here, is not subject to the Constitution. The Constitution does not tell him what he can and cannot do. He is only, as the as how this system is set up, he is only governed by common law and equity, which is essentially based on principles of morals. However, I would say equity has more moral principles, in my opinion, than common law. And I only say that because there are more remedies in equity than they are in common law. Well, there seem to be based on my research. Let's see. Okay, so but yeah, John Henry Doe he's not subject to the Constitution of Georgia, but the Georgia Constitution is the supreme law for Georgia. Okay, so if John Henry Doe is not subject, to the Constitution, meaning he's not prohibited from doing something by the Constitution, how the fuck is he prohibited from doing something by fucking statute, which is inferior to the Constitution? It makes zero sense. They ain't gonna tell y'all this shit. Y'all can call motherfuckers crazy all you want, but they ain't finna tell you this shit. They're not gonna tell you this. You can forget about that. They are not going to tell you this. I believe that, maybe in the older cases they might have done it, but you have to go on a damn wild goose hunt to find old cases to substantiate some of the stuff of what I'm saying here, because they're hiding this stuff and they're doing a damn good job at it by changing the words. That's what they're doing. All right. So John Henry Doe, this is where the legal fiction, the person, the mask, he lives on 123 Street in Atlanta, Georgia, blah, blah, blah. Notice all these these are all territorial areas. All of this stuff, in my opinion, was created under some sort of act of the legislature, whether it be federal or state legislatures. So I want to read something to y'all in regarding, private rights and stuff like that. In the preceding section, we observed that the use of home rule powers was not anticipated to extend to such matters as divorce, real property law, trusts, contracts, etc., which are generally recognized as falling within the competence of state rather than local authorities. The rationale for excluding such matters as divorce, real property law, trusts, contracts, as matters which generally recognized as falling within the competence of state rather than local law is implicit within the one characteristic shared by these areas of law. All right, so these right here, like divorce cases, real property cases, those are generally, they used to do it in some of this stuff they used to do it in a court, but then they changed it over, if I'm not mistaken, to a court of chancery, which is another word for a court of equity. So now today, divorce, real property, trust, anything dealing with guardian ad litem's, trust, contracts, like business related, something like that, to a certain extent, equity is going to be you're going to have to litigate it in a court of chancery, generally speaking. What we at? Right here. Okay. Let me see. What we at? I want to go back. The rationale for excluding such matters as divorce, real property law, trusts, contracts, etc., as matters which are generally recognized as falling within the competence of state rather than local authorities is implicit within the one characteristic shared by these areas of law. These areas of law are all matters of private law. That is, they govern civil relationships. So let's go down a little bit more. Crucial to an articulation of this common characteristic is an understanding of the distinction between private law and public law. Black's Law Dictionary defines public law as that branch or department of law which is concerned with the definition, regulation, and enforcement of rights in cases where the state is regarded as the subject of the right or the object of the duty. Let's go down a little bit more. Black's Law Dictionary defines private law as used in contradistinction to public law, that part of law which is administered between citizen and citizen. Notice they have this lowercase c, or which is concerned with the definition, regulation, and enforcement of rights in cases where both the person in whom the right inheres and the person upon whom the obligation is incident are private individuals. Public and private law are not always separated by a clear line of division. For example, it is a common practice for a court to refer to a municipal safety regulation enacted pursuant to its police power as a standard for determining whether an individual is guilty of negligence. In other words, the distinction is one of emphasis and viewpoint. A public law has as its focus and thrust a protection of the public interests. A private law essentially governs civil relationships, adjusting conflicts between individuals, private individuals. So essentially, it's just anybody who's not in the military or not a public, servant. That's essentially who private law is for. There's the case right there in support of that contention. Here's something else I found very interesting, by the way. The distinction between public and private law is well recognized in the Anglo-American legal system. Blackstone acknowledged the distinctness of these two bodies of law. Blackstone's Commentaries of the Laws of England. Let's see, page 1, private wrongs, volume, blah, 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 public wrongs, blah, blah, blah. He defined a private wrong as an infringement or privation of the private or civil rights belonging to individuals. Notice that you see private rights or civil rights, because private rights and civil rights are not the same thing. Civil rights, in my opinion, are derived from positive law via statutes, meaning the government gives you rights. Okay. Private rights are inherent. You're born with these rights. These rights are inalienable. They come from God. These rights are ascribed to you from your maker, the creator, at birth. I keep telling y'all they playing a fucking word game with y'all. Y'all think I'm playing, but I've read enough cases to know that this is a damn word game. He defined a private wrong as an infringement or privation of the private or civil rights belonging to individuals, considered merely as individuals, and therefore termed civil injuries, while public wrongs were described as a breach and violation of public rights and duties affecting the entire community, considered as a community, which is a statute, by the way. When they say public, they're talking about the government. That's what they're talking about, generally speaking. In this case, they're talking about the government. Notwithstanding Blackstone's late 19th century teachings, the term public law is not commonly used in the United States. And there's the case right there to support that contention. Now, I'm sorry I had to make this video so long, but I really just wanted y'all to see this shit. It took me about an hour to do this, but the name thing in court, in my opinion, it works. Sometimes it doesn't work. You should just try it out to see. But if you're going to do it, you need to know what you're doing, because if you don't know what you're doing, you're just going to make people who truly understand this information and who know how to argue it, you're going to make us look bad. And you're going to make yourself look bad. You're going to make people really think that people who think like us are crazy when we're not crazy at all. These people are not going to tell y'all this. You can forget about that. They are not going to tell you this. So this right here, this John Doe, he exists in my opinion, he exists somewhere in their territorial jurisdiction. Okay, in that territorial jurisdiction in which this legal fiction exists, they have plenary power in that jurisdiction. Meaning, that's why you have all those administrative agencies over there. And since they have plenary power, they're going to be exercising legislative, judicial, and executive so-called powers over there in that jurisdiction. All right, so it's that particular this John Doe right here. He needs to do his best to stay the hell out of the territorial jurisdiction. That's what he needs to do. So, but anyway, I hope this video explained this stuff to y'all, in a way to where you can understand it. All right, that'll be the end of this video. The Supreme Litigant is out. Peace.